Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss a case law on dying declaration, section 32 of the Indian Evidence Act, in which it was held by the Honorable Supreme Court of India that the signature of the person who recorded the dying declaration is essential to prove the same, as stated in the case of Manjunath and others versus State of Karnataka in Criminal Appeal number 866 by 2011, decided on 6/11/2023 by two judges bench, that is Honorable Justice Abhay Srinivas Voka and Sanjay Karol. You can see this judgment on Live Law 2023 SC 961. Very beautiful judgment. Lot of principles have been given. Directions were also given as regards the dying declaration. The principles regarding dying declaration were discussed a lot. So please read the judgment without fail. Right? Now coming to the facts of the case. This incident took place in the year 1997, maybe 4th August 1997, where the accused, that is the so-called Ajay Verma and others, in a gory mob went upon the deceased who were working in the fields, attacked them with clubs, daggers and other deadly weapons, as a result of which some of them fled away from the spot, and ultimately the deceased was caught to them. They caused him injuries due to which he died. Immediately he was shifted to the nearby hospital, where the police went there and recorded his so-called dying declaration, section 32 of the Indian Evidence Act. The accused was arrested, some weapons were seized, so many direct witnesses, about 5 direct witnesses. Their oral evidence has been recorded, and according to section 173 CRPC, the police filed the charge sheet. But the trial court filed the charge sheet against 29 persons. But the trial court acquitted all of them, since it did not belong the dying declaration. No doubt we say that it is an exception to hearsay, and we say that truth lies on the lips of the dying person, all these things, but they did not believe it. The main point is, it was not established, or the person who scribed the DD was not examined. He was not cited. He is a police officer. Right. Later, the matter went to the in the shape of appeal to the High Court of Karnataka. High Court of Karnataka, believing the dying declaration, gave conviction to 6 persons with under, of course, not under 302, under 304 part 2, 4 years. Agreed with this, once again the accused people, the people who are convicted, they came to the Honorable Supreme Court of India. Supreme Court of India reversed the appeal and only allowed the appeal, holding that only very important point, that the dying declaration is not, the person who recorded the declaration is not cited as a witness. So in this connection, the Honorable Supreme Court of India discussed the principles regarding the dying declaration. Circumstances disclosed in the dying declaration, please remember, they must have a proximate or nearer relation to the actual occurrence. This is what is stated in the case of Pakala Narayanaswamy versus Emperor, 1939. So don't forget to mention this case as and when the topic of dying declaration comes. Then, if dying declaration inspires confidence, it can be conclusive. It can form the basis of conviction even without any corroborative evidence. Of course, this is only in, I can say, rarest of rare cases, but corroboration is necessary. that court must assure that the deceased was in a fit state of mind for dying declaration. That's why whenever the dying declaration topic comes, so for example, a person is having so many injuries and the doctor, the medical officer cannot decide whether the person will survive or croak. In such circumstances, so he has to send an intimation to the police as well as to the concerned magistrate. So that is intimation relating to accident and injuries. In this intimation, if he says column number 7, if a dying declaration is necessary, then the judge or magistrate will come and record the dying declaration. But the person may not be alive till such time. Therefore, the leverage is given. The dying declaration can be recorded anybody. Sometimes police officers, they record the dying declaration. Sometimes the medical officer, they record the dying declaration. Here, the police officer recorded the dying declaration. But before that, they have to get a certificate from the medical officer that this patient is conscious, coherent, and in a fit state of mind to give the dying declaration. That is what is required. Court must ensure that the deceased was in a fit state of mind for giving dying declaration. Then, if there are witnesses who were present during the while giving the statement, their statements would prevail. So, if they are said, if they reveal the evidence that they were present and this man has spoken to them, that will be better evidence than the so-called medical evidence also. Of course, there are certain occasions where the doctor may be attending on the other patients and may not give a certificate that this man is in a fit condition. It is not that necessary. It is only directory but not mandatory. Please remember. If in case of multiple dying declarations, please remember, reliability but not plurality. Reliability of so-called dying declaration will define or will decide the evidential value. And the presence of magistrate is not necessarily, is not a necessity, but only a rule of prudence, better, or sanctity. Dying declaration not to be discarded only due to some brevity. If the person gives DD in a simplest way, so you can't take it away. So please remember, a dying declaration must be free from tutoring, prompting, or imagination. This is very, very important. Whenever the topic of dying declaration comes, please remember, it should have approximate relation to the incident. This is what is stated by Pakala Narayanaswamy. Another case is there, that is Pulkur Kotaya. That is also another case, important case. And please remember the very principle, Madan versus State of Maharashtra 2019. So they also stated that the truth will be lying on the lips of the deceased person and they will not speak any falsehood. This is more important. So a lot of case laws have been discussed. Ultimately, the court allowed the appeal and upheld the judgment of the trial court. Right? Please read the judgment and enrich your legal knowledge. Thank you.